sponsored in part by Pediatric Associates of Dallas. Pediatric Associates of Dallas has been providing excellence in pediatric medicine since 1971. PAD has locations in Dallas and Plano and is now open 7 days a week because taking care of kids is what we do.
The following content is not intended as a substitute for professional legal advice, medical advice, diagnosis, or treatment. Always seek the advice of your attorney, advocate, physician, or other qualified health provider with any questions you may have regarding any medical or educational concerns.
Good morning, everybody. Welcome to Empower Dyslexia. I'm Stephen Yearout.
And I'm Rachel Chambers.
On this show, we discuss all things dyslexia, related disorders, policies at the local, state, and federal level. We also discuss all the different types of intervention that you can possibly receive. Special education. We also bring in experts in the field so they can provide the most relevant information that's out there for our guests. So we are so close to our goal of hitting 1,000 followers and subscribers.
Followers on Facebook and
subscribers on YouTube. So on Facebook, we're at like 947. So I mean, we're right
so
there.
Close.
YouTube, it's picking up a lot. We're at 483.
That's crazy.
Yeah.
So our goal for the end of May is to do 1,000, have 1,000 people on Facebook and
well, we wanted 1,000 on both.
On both, yeah, but you know.
So if our Facebook people are our Facebook people are out there, go out to our YouTube and subscribe to us over there. So.
Yeah, it helps. It will help us in the long run.
Absolutely.
Stay here.
we got an amazing show this morning. So.
We do. Big show. We're discussing a court case that was just decided upon. The court case was in the Fifth Circuit Court of Appeals, which is down in New Orleans, and they just ruled in the parents' favor on May 15th. And to help us walk us through that case, we have on the line with us Sonia Kerr, who is a special education attorney, and the parent Lisa Malden. And Lisa, she's a parent. She's also a social worker. Her child is twice exceptional, meaning that he is brilliant.
Well, he's gifted in areas, but he also has a disability, such as dyslexia.
Hidden disability, which you can't tell that he has anything wrong. But he has ADHD, dysgraphia, developmental coordination disorder, which I think is a little bit like, if not completely like, dyspraxia, but don't quote me on that, and dyslexia. Sonia is a special education attorney, and she's had her master's in psychology. She has her law degree from Indiana University, and she's been practicing law for over 30 years and has successfully represented parents at all levels, due process, federal and state courts, and the appellate court. She does individual cases and class action cases. So good morning, ladies, and welcome to the show.
Good morning. Thank you for having us.
Good morning.
Awesome. So glad you guys could join us on this I feel like it's quite an accomplishment.
It's absolutely.
But we'll get it. We'll find out more details. So Sonia, tell us a little bit about yourself.
So my background is psychology. I have a bachelor's and master's in that, and I worked before I went to law school. I worked in the juvenile justice system in Indiana in the county attorney's office, and I also worked with young adults with disabilities, and that eventually led to my going to law school. And I've practiced in many places, and I'm licensed in several jurisdictions and in federal court and circuit courts. So that's kind of my story.
So you've been doing this for a while.
Yeah, it's been an interesting adventure. The piece that's most interesting is I think that it was good that I came to Texas with many years of experience, because Texas is a challenge.
Absolutely.
Yeah, Texas is definitely in trying times.
Yeah, here in Texas,
so to speak,
we don't like to be told what to do, and we want to do it our own way. And sometimes we need
some guidance.
Yes.
Or I don't know what the correct wordage is for that. I'm not from Texas, but I've been here for quite a while. And but anyway, so Lisa, why don't you tell us a little bit about yourself and give us a little, I guess, snapshot of your story.
Oh, goodness. I'm a mom. I currently have 2 still at home. Both have special needs, disabilities, learning disabilities, etc. I've been in social work for over 25 years. And as far as the story, not something you ever expect as a parent. We, had our son enrolled in school and knew that there were some issues early on. But being naive, listen to teachers. You think the school and the teachers and administration are the professionals, and there were always excuses and things for what was going on, and seemed to get swept under the carpet for a long, long time, until we started advocating and questioning and digging and educating ourselves, and then things got a little hairy.
Well, so you said you started noticing things early on. How early did you notice that there was a problem and that your child was struggling?
He had a couple of diagnoses before he ever started school. In first grade, he had a teacher, kindergarten, he had a teacher in Leander ISD that was previously a SPED teacher, but he was in general ed. And she recognized the issues and worked with us, but never referred him for services. Then we moved elementary schools, in first grade, and he kind of became labeled as a behavior problem and was treated as such. So by second grade, and some of those behaviors and treatment worsened, we started looking at what can we do here. And we asked for services, and we were told no, that he didn't qualify, he was bright, his grades were fine, et cetera, et cetera. And so we went outside and had a private evaluation that showed he had dysgraphia and ADHD and developmental coordination disorder.
Hmm.
We brought that to the school, and we were told, well, we don't do anything for dysgraphia, but we can give you a 504 for the ADHD. Again, I'm like, okay, great, we're going to get some services, because I didn't know any better at that time.
And how long was he in 504? And I read the case that's online, and it said that he was in RTI as well, or he was in 504?
He was in RTI, and we didn't actually find that out, or for how long he'd been in, or what tier he was at, or anything, until we started, until after we had filed due process and started doing records requests. And that's when it was discovered that he had actually been in RTI since first grade, and we never knew it. And actually on tier 3 for 2 years.
Mm-hmm. So then what happened?
continued to have issues and an escalation of symptoms through third grade. He was being punished more and more. He started having stomach aches chronically, and even in his private testing in second grade showed that he was at the clinical range for somatization. He was stressing over the issues he was having at school.
And for those of you who don't know what somatization, I can't even say it this morning, it means that they're so distraught mentally that they start manifesting stomach, like you said, Lisa, stomach pains, stomach aches, headaches, can't sleep at night, anxiety, depression. Well, those are two other diagnoses, but yeah. So I just wanted to let our listeners, viewers know what that was, even though I can't say
Well,
it.
I mean, something else to add to that is, we hear that piece of it a lot.
Yeah, they
from
start
our
acting
kids.
out.
They start having that, I'm sick. And
Don't want to go to school.
And the parents think, oh, well, they're not, they're just faking. They just don't want to go to school or whatever else. But
it's
I
a
mean,
true,
it's
a true diagnosis.
right. So, that's the other piece of it. So they actually are sick at the stomach. They
actually
do
are.
have,
The brain is
Yeah.
trying to block whatever it is they're having a struggle with and manifest it in an illness type way.
Sorry.
It's very fascinating how the brain works like that. Sorry, Lisa, go ahead. I'm sorry.
No worries. So we get through third grade, and by this time I was really starting to delve into other options. What can we do? This is not working. Things are getting worse, and started connecting with other parents and started getting educated about special education. And so before school even started in fourth grade, I put it in writing this time and sent a request for our son to be evaluated for special education services.
Great.
Initially, we were told no because he was passing, his grades were fine, he had scored in, I believe it was the first percentile. He was one or two questions shy of having a perfect score on the STAR, which was used against him from forevermore after that. And again, we were in the middle of another private evaluation. It had been 2 years. We went back and had another one. Again, it showed he had a specific learning disability in written expression, ADHD, developmental coordination disorder, etc.
So it basically mirrored the private report that you had hired someone
Correct.
to do.
Correct.
Okay. That lines up.
So they finally agreed to do an FIE, a full individual evaluation. And when we came back to the table to review that, it did not seem that they had covered all areas, and I was a little concerned. So we wrote the special education director of the district and asked that they redo it or open it back up. And it took some doing, a couple of emails back and forth, a couple of phone calls. They did it. They added some further evaluation and testing, and we ultimately came back for the review of all of that then in January of 2016. He was halfway through fourth grade. At that meeting, which was approximately 3.5 hours long, it was agreed that he indeed did meet all qualifications and was eligible for special education services.
So let me jump in right here. So now we're at, you said fourth grade, correct?
That is correct.
Can you tell our viewers and listeners, kind of what was your son like at this point? I mean, now he's gone through 4 years of school, or I don't know if he went to kindergarten, 5 years of school, not being identified, not getting, from what you're saying, not getting the help or as much help as he needed. How is he now at fourth grade?
Well, he was not fond of school. We had a lot of school avoidance, task avoidance, the chronic stomach aches, some acting out. He was a bit of a class clown. He was never aggressive or hurtful to anyone, but he was acting out a bit. Felt like nobody liked him. Felt like he was always in trouble, which explains why he didn't want to go to school.
It's understandable. So yeah, now we're in the middle of fourth grade. They've agreed to do the FIE process is going. Now what's happening at this point?
And you're at your ARD, your first ARD?
Correct. I guess it was the review and the ARD all wrapped into one. We agreed, the school agreed, everyone agreed at the table that he qualified for special education services, and then spent some time talking about what those services would look like. What were we going to put in the IEP? We left that meeting thinking that he was in special education, that the services were going to begin. My husband happened to be out of town that week on a business trip, so I didn't sign the paperwork at the table, but that was not unusual. I did verbally tell them we agreed with the services. They set another date for another ARD if we should need to come back to the table to discuss anything when my husband returned. And I believe that was scheduled for February 5th. This was January 25th. We reviewed the paperwork. We talked about it. I talked with some other parents and folks that I knew in the field or in the special education world, and decided that the IEP that they had proposed did not address all of his needs, not even close. There were 2 goals in that IEP. They had identified at least 9 areas in their FIE in which he needed services, areas that needed to be addressed. So 2 goals just didn't seem sufficient.
Right.
I wrote them back on February 3rd and said that we agreed to their diagnoses in the FIE. We agreed to implementation of special education services, but we wanted to come back to the table to discuss the IEP, and that I would be bringing an advocate with me because I didn't know anything about IEPs and really wanted someone that could guide us in that area in helping us identify, what he needed, what services, what goals, etc.
Sure.
They quickly returned an email and canceled that meeting for February 5th. Shortly thereafter, called and rescheduled it for February 23rd. Their explanation on the phone at that time was because they were going to have to get together the proper staff, as you will, make sure that, representation was there, meaning their attorneys, I guess. So we went to the next ARD. There really wasn't a lot of communication in between. Went to the next ARD on February 23rd, and they had indeed brought an attorney from an outside firm. I don't know if I'm allowed to say the firm or the attorney's name, but we thought we were going to be discussing an IEP and how to better serve our son, and it ended up that they had a meeting somewhere between January 25th and February 23rd and decided that our son no longer was eligible for special education.
So you found out right then at the ARD meeting that had been delayed that your son, at the beginning, your son had qualified for special
Yes.
education. And then at the second ARD meeting with your husband present and your advocate present, you found out that he no longer qualified.
Correct.
So what happened exactly? I mean, or do you even know what happened? What made them change their minds? Because the information was there, it sounds like. Did the information just kind of vanish or something?
Well, we kind of asked that at the ARD table. It was like there was no other testing. There was no other information. We actually sat down and calendared how many days our son had attended school in that time frame, and it was only like 6 or 7 days. There was no other information. It was the only information they had available was the information that had been reviewed in the 3.5-hour ARD previously where they found him eligible.
So at what point did you and your husband decide that you needed to get legal representation?
Yeah. When did Sonia, when did you come in the picture?
We left there in shock. And I believe we next, tried to talk with staff. I mean, I elevated it up to the principal. We went to the special education director. We formally requested mediation, and they denied us.
So it sounds
Nobody
like
would
you were
really
doing,
talk about it, so we started searching for an attorney.
It sounds like that you went down the list of all the things that you are supposed to do to try to work
Together
to make sure that you're being a
Absolutely.
partner in this education, like what we talk about.
Like what an ARD meeting is supposed to entail, like everybody working together,
Right.
equal parts, making the best decisions for the child.
And we have that question quite often. We hear parents ask that question. When do we get an advocate? When do we get an attorney? And there's you want to make sure that you're going down the list of things that you're trying to do to be collaborative, working with that team.
Because you don't want to destroy any relationships, so to speak.
You're going to be with, especially if you're in the 4th grade, you're going to be with that ISD
For a while.
unless you move. So you reach out and find Sonia, and this is where Sonia becomes involved.
So Sonia, what happened then?
So this case came in, and there were actually a number of families sat in the Leander district. In this case, when I got the file,
Hey,
I
Sonia,
being,
Sonia, hold on just a second. Can you mute your speakers for just a second, please?
Because we're hearing two
Yeah, I'm
things
hearing
at the same
feedback.
thing.
Sorry.
Is that
okay? Is this better?
Awesome.
perfect? Yeah. Okay. Continue. Sorry about that.
So when this case came in, there were a number of families who were upset in the Leander district. And just to put it in context, there had been parent advocacy and parents unhappy in the Leander district for some time. And one of the individuals who had been advocating very strenuously in that district was the advocate that the family ultimately used, Jana Pulser. And Jana had actually been with a different group of parents, an older group of parents, advocating for quite some time. Her child was quite a bit older than JM. The interesting thing to me when the case came in was really two facets. First of all, the child was bright. He had not, however, qualified for gifted services in Leander. And part of that was his difficulty in terms of completing some of the test work for that, which the parents believed included writing. The second piece that was most curious to me was that the team had agreed at long last that in January that the child was eligible for special education. The parent had sat in that meeting. They had written an IEP. The paperwork reflected that everybody was in agreement that the child was eligible, and that was paperwork prepared by the school district. The parent had received an email prior to that meeting from a special ed teacher saying, "I'll be your special ed teacher of record. Here's a draft of the IEP." Mm-hmm. And, that meeting was taped, was a friendly meeting. Everyone was talking about how to help the student. And at the appropriate point, the school district people said, "We believe he's eligible. Mom, do you agree he's eligible?" And Lisa, of course, said, "Yes, I believe he's eligible. I want him eligible." And then they talked about the IEP, and they wrote an IEP. They completed an IEP, and the IEP was going to go into effect. The only question was if there needed to be some changes to it because Dad was not able to go to the meeting. And so the most astounding thing about the paperwork then was that Lisa sends this innocuous email saying, "Hey, we definitely want him in special ed. We have some concerns about the IEP, and we should get together, and when we get together, I'm going to bring this advocate, Jana Pulser." And the school district response to that was another piece of the record that just seemed astounding to me. They seemed to sort of batten down the hatches, say they were going to have an attorney at the meeting. They brought attorneys anytime this lay advocate came to meetings, and the climate changed drastically. And then, as Lisa said, there was unbeknownst to the family, two things happened. One is an addendum to the full individual evaluation was completed and eventually given to the parents. That addendum, to my surprise, reiterated that the child was eligible. So now we have not only the first evaluation and the IEP, but the addendum to the evaluation saying, yeah, he's eligible, and here's some more information. And then despite this, there's this secret meeting, which the school district calls a staffing. The school attorney attends. Her name is Denise Hayes. She works for the biggest school side law firm in the state of Texas, Walsh Gallegos, and basically, as a result of this non-attended, this meeting that parents were not told about and were not invited to, the decision is made that the student is not eligible. The school district's version of the story is that they sought out counsel because the parent was not happy with the IEP, so they were trying to figure out what to change. And in the course of that discussion, it just kind of happened that it was decided he wasn't eligible. So,
but there's
proof that he
there's
was.
guidelines that says you have to meet these guidelines in order to be considered eligible to be in special education, correct?
Right, and he had met those. So he was carrying an outside diagnosis of ADHD, which the school district did not contest. And as the Fifth Circuit ultimately pointed out, indicates in the criteria for ADHD, it indicates that, if you think the kid has ADHD and you say that the child has ADHD, that, there's a presumption in the regulation the child needs special education. We also had this outside diagnosis of developmental coordination disorder or dysgraphia, depending on who we were talking to. And the neuropsychologist would refer to it as dysgraphia. The medical doctor would refer to it as developmental coordination disorder. But the long and short of it is that the child's fine motor skills were extremely, extremely poor, tested by 3 different occupational therapists, including the school district. He had just tremendous difficulty with the physical maneuvering of the pencils. So, but the story that came to me as it was unfolding was really bizarre in that this team had met, they had agreed the child's eligible, they had done another addendum and said the child's eligible, and then in response to the parent asking for a change to the IEP and saying, I'm bringing an advocate, the school decided he wasn't eligible. So,
Okay, we're back.
Sorry about that. We had some technical difficulties.
Yeah. Okay, Sonia, you were in the middle of.
Our program.
Take it away.
yeah. Yeah, I think I was just explaining about the parent's request for an independent educational evaluation. So we had that request made in the spring, and the district, not surprisingly, said no, we won't do one. And we will defend our evaluation at the hearing. And that was actually the district's undoing, because when we had the hearing, since they would not mediate, we had the burden to show that, essentially he did need special education, but they had the burden to defend their independent educational evaluation, because they had, or their original FIE and FIE addendum, because they had refused the independent evaluation.
So they did the evaluation, and then they refused their own evaluation?
And their IEP.
No, it's a little more simple if you look at it this way. So they did the evaluation, and they said he was eligible, and then they did the IEP and said he was eligible, and here's your IEP, and then they somewhere in between there did an addendum, I think after the first meeting, the first ARD meeting, that said again he was eligible. And then after the parent asked to change the IEP, they said he was not eligible. So they gave a notice at that point of non-eligibility. And that was the basis for our filing for the due process. And we also asked for the school district to pay for an independent educational evaluation. Mm-hmm. And they said no. So they then had a counterclaim. They filed it as a counterclaim in the hearing that we had asked for, saying, we're going to prove up that our evaluation was correct. I guess it never dawned on them that if their evaluation was correct, then he was eligible. Mm-hmm. Because the whole way they approached the case was just odd. I mean,
well, maybe they just
in
didn't
that
think,
regard.
They didn't think that y'all were going to go actually, the next step and take it to due process. I mean, maybe they're bluffing.
Once we requested the independent evaluation, they would have been better off giving an independent evaluation, because as it was, they had to go into this hearing and essentially, to avoid losing on our request for the independent educational evaluation, which we did lose and before the hearing officer, they had to prove up as correct the evaluation and the evaluation addendum that they had just ignored and said, we're not going to follow and he's not eligible. So do you see the conundrum they were in? Mm-hmm. The school spent a little over 2 hours or more with one of the school psychologists on the stand, talking about the evaluation and how explicitly, correctly they had done it, how all the tests were right, all this kind of thing. I had an associate attorney who was doing that part of the case, and was all excited about questioning the school psychologist. And in the end, we didn't ask too much, because the school psychologist had essentially proved our case, that the child was eligible, that the evaluations they had conducted proved the child was eligible at a time when they were saying the child is not eligible. Mm-hmm. So basically, I'm not sure what their strategy was, but that was the net result of it. And the hearing officer then ordered them to implement the IEP, to make some changes to the IEP, which they didn't completely do, and is the subject of other litigation that I won't get into. But the basic result of the opinion of the hearing officer was that the school staff had been instructed, trained, or coached during the staffing meeting to find the child not eligible. And in the context of what was going on in Texas at the time, and particularly with the Leander district, Leander had a very low child count. A lot of districts in Texas did, but Leander's was specifically low. And, at a time when, the national average was 11 to 13%, Leander was extremely low. And so basically the belief of the parents, and I think to some extent the hearing officer, was that this was an intentional gatekeeping type of activity, that, well, this was, a child who really didn't need special ed because he was smart, and we're not going to give special ed. And in fact, one of the witnesses, Uli Crane, who was at that time some type of administrator for the special ed department, testified that, well, if this kid is eligible, everybody's eligible.
Mm. Really?
And that was sort of their attitude.
That's very sad.
And I think we should stress that, at every level, before the due process hearing and when we were in federal court and, all the way along, we tried to negotiate with the district to resolve the disputes. And essentially, it was a pretty big no. Mm-hmm. So after the hearing officer had also ruled that as a procedural matter, the district had violated prior written notice, because after the IEP meeting, they didn't tell Lisa, well, we're not going to implement this IEP by sending a prior written notice. That ultimately is reversed by the district court. But the important thing about the district court opinion as a decision for kids in Texas was that the hearing officer had said, look, I'm listening to these school people, and I listened to the tapes of the meeting, and what they're telling me in this hearing is not consistent. I mean, he essentially kind of called them out, like, you're really not telling me what actually happened.
Wait, Sonia, so there was tape recordings or audio recordings of the IEP or ARD meetings, the two ARD meetings?
Yes. And he listened to them. Mm-hmm. And he said basically, the meeting in January, the teachers don't sound at all like the teachers in February. And then the teachers who testified don't sound like the teachers in January either. And so he was like, wait a minute, this doesn't make sense. Mm-hmm. And the district court, and that is, in the law, that's called making a credibility determination. And the hearing officer basically said, I don't believe you, to the school staff. I don't believe your testimony. That's a credibility determination. And he particularly did not believe the testimony of Uli Crane, who was the administrator. Mm-hmm. And the district court decision is also significant because we prevailed at the hearing. We didn't appeal any part of the hearing officer's decision, though we could have. We didn't. We simply filed for our attorney's fees, and in response, the school district filed an appeal of the hearing officer's decision. And it looked, frankly, like they weren't certain what they were doing, because remember, they said in their own eval in the IEP and in the evaluation addendum that the child was eligible. And then they went to hearing, and their witness, defended all of the evaluations they had done, which was inconsistent with their determination that the child was not eligible. So they tried to get around this by saying, well, yeah, we kind of acknowledge that he has these disabilities, but he doesn't need special education. That was their argument at hearing. That was their argument before the district court. And the hearing officer and the district court didn't buy that. And they didn't buy it because the evidence was pretty much overwhelming by the district's own created evaluations and IEPs that the child did need special education.
Right.
So the district court reversed the procedural violation, but maintained that the child was indeed eligible for special education. And then the school district appealed again to the Fifth Circuit. So this was a case that was watched carefully by the disability groups. Disability Rights filed an amicus. Decoding Dyslexia filed with Disability Rights and amicus, and then the Council of Parent Attorneys filed an amicus. School district, I believe the school district lawyers just thought, well, the Fifth will believe us. Even the briefing that they did before the district court was confusing. So, for example, in the briefing before the district court, they tried to explain away the fact that they had found him eligible by saying, oh, well, it was just a mistake that we found him eligible. And they literally, in their brief, quoted Coach Bear Bryant, saying, well, if you make a mistake, you should own up to it, blah, blah, blah. So they tried to say that their original determination that he was eligible, the original IEP, and the evaluation addendum were all just a mistake. But they couldn't get around the testimony of their own person during the hearing who defended those evaluations and said those evaluations were correct. So, the district court was not impressed. I mean, his opinion's pretty blunt, and the judge was Judge Sparks, who was himself a special education attorney, a school attorney, before he went on the bench, and he's quite elderly.
This is the one that's in the Fifth Circuit,
he hasn't ruled
correct?
for parents a lot.
And Judge Sparks is the one that's in the Fifth Circuit, correct?
No, Judge Sparks is our Western District Court, U.S. District Court in the Western District of Texas. So his office is in Austin. He is the judge who made the district court opinion. So it goes special education hearing decision, and then district court, Western District of Texas in Austin with Judge Sparks, and then to the Fifth Circuit.
Okay.
So the Fifth Circuit panel was Judge Higginson, Judge King, and Judge Costa. Judge Costa had been a Teach for America teacher. Judge King has been on the bench for a long time and did some of the very early cases about segregation, racial issues, and things like that. English as a second language cases and stuff like that. Judge Higginson was ultimately the opinion writer for the case, and I think he got it instinctively based on the fact that his questions at oral argument, and you can listen to the oral argument. It's online at the Fifth Circuit Court of Appeals. You just go online, you can press a button and listen to it. But his comment was, but the teachers originally said he was eligible. Then they had the IEP meeting, enrolled in IEP, and they had another addendum that said he was eligible. So I think that part of his analysis was, well, the teachers themselves said he was eligible 3 times, and yet they have this meeting that they call staffing, that we call a secret meeting, and the only thing that changes is that there's an attorney there.
Mm-hmm.
And the district court opinion actually called out the attorney by name. And the Fifth Circuit did not. But in the Fifth Circuit, the basic gist of the opinion was really 3 things. One, the credibility of the witnesses at the hearing is something that is very difficult to reverse, because the only person hearing them testify is the hearing officer. And so it's just like a regular trial court, which is the first time that I've seen a circuit court really explain this well, but it's true. So these hearing officers we have are really like, it's like a bench trial in a regular court as opposed to a jury trial. And so, the credibility of a witness and whether the judge thinks they're telling things accurately is left to the hearing officer. And it's very hard to change that unless there's a good reason. And that was a big finding by this circuit court. The reason that's important is because in the Fifth Circuit we have been having many cases where parents might win at the hearing level and they might win at district court, and then the circuit court will reverse, and there's not necessarily any basis for the reversal because of the credibility findings of the hearing officer. So that was one really huge issue that was brought out. Of course, the main point that the Fifth Circuit made was that this child was eligible, notwithstanding the fact that he could get decent grades. And they relied on firm United States Supreme Court precedent from the Rowley case that basically says, you don't say that a kid can't be eligible just because he's passing from grade to grade. You don't have to flunk to be eligible for special education. You don't have to be retained just to be eligible for special education. You don't have to have failing grades to be eligible for special education. It will all depend on the independent nature of the child's needs. And that was a big decision because the school districts in Texas have been taught by their attorneys that a child's not eligible if they're making good grades. And that is one of the reasons for the very, very deficient identification of children with disabilities in Texas. It's not the only reason, but it's part of the reason. So this court said, no, that's not the case. A child can need special education services even if the child is doing okay, because there may be a unique need, there may be an individual need. The court took the time, which was impressive, to explain, there's response intervention, there's Section 504, there's these various other services, but when all is said and done, those services can't be used in a way to delay special education identification and services, and that the United States Department of Education has been very firm on that, and has issued opinion letters on it, and the court relied on those and basically said, look, the fact that this child had a 504 plan doesn't really mean that you don't need a special education IEP, because they're not the same thing. Mm-hmm. And we did spend a great deal of our brief trying to explain that concept to the court, because we felt it was a real critical aspect of the case. As Lisa said, they didn't even realize that her son had been in quote-unquote response intervention, some sort of reading program or whatever it was, until they were in the due process hearing. That should never happen. And, when they ask for special education and we're punted to Section 504, that should never happen.
Mm-hmm.
It should be parent choice, and it should be informed parent choice when a parent is looking at, well, do I want an IEP, or do I want 504, or do I want response intervention, or do I want dyslexia services, or whatever.
Right.
And, and that did not happen in this case. So, it's a strong decision. It's a carefully written decision. And I think the other piece that's really significant is the court's explanation that, when you are deciding eligibility, you have to go with, at the time you're deciding it. So the fact that the child ultimately makes other progress or doesn't make other progress in terms of eligibility is not really the right standard. And the court actually asked a couple questions about that. And I think because school districts are often doing things like they'll have a child in 504 land or RTI land, and the parent asks for special ed, and then, they'll be denied special ed, and the school will say, oh, see, he's doing okay.
Mm-hmm.
And the court is saying, no, you have to look at the time and the point when the parent asked, the time and the point when the evaluation should have taken place. And it's because it's very confusing for families and schools, I believe, that we have these other types of programs. And the court's trying to say, well, yeah, but the special education program is very different. Mm-hmm. You get an IEP, you get services, you get, individualized goals and things like that.
You get progress reports.
You get protection.
Yeah, right. So that's kind of the gist of it is.
So with this case coming down on the side of the parents, you kind of explained this, but in a elevator type pitch, how does this really affect or help? I shouldn't say affect. How does this help the rest of the children here in Texas?
Well, I think Judge Higginson's opinion makes it quite clear what the process is, what the evaluation process is supposed to be. And, right now, Texas is under a corrective action order from the federal government for not timely identifying hundreds of thousands of children, particularly children with dyslexia and related disorders such as dysgraphia. So our hope is that school districts will read this opinion and realize and be reminded that they cannot just, arbitrarily determine eligibility. Eligibility is a very serious determination. It should be a very thoughtful and deliberate process, and it should not be just thrown out because a parent disagreed with the IEP. Mm-hmm. In some worlds, and people have asked me about that, well, wasn't that kind of retaliation? Well, it's hard to prove retaliation claims, but I believe, and I think the court pointed out that email from Lisa showing that, the only thing that changed was she said, I really want to look at this IEP and maybe make some changes to it, and by the way, I'm bringing an advocate. All the world went crazy.
Which is in her right to bring in an advocate.
I'll ask this question. It's bringing in a parent's right is to bring legal representation or an advocate without it being
or a family member
or a family
someone
member,
somebody to support them during this very
to help them understand
tedious,
what's going on,
mm-hmm.
or another
emotional
set of ears, right?
Mm-hmm.
And that shouldn't be seen as adversarial or confrontational, correct? I mean, this is not. There's
it
thousands
shouldn't be,
of
but in the Leander
there, right?
district, it has been.
Okay.
And in the Leander district, they have been, I believe, quite, shall we say, litigiously oriented. Mm-hmm. For example, they now have 2 in-house lawyers that regularly go to meetings. They have their own paralegal for special education. they've spent, so if you just set up the salaries of just those people,
Yeah, please do. I'm
you know,
curious.
it's probably, you know, $200,000-$300,000 that they have made a conscious decision they will spend
A year?
to, yeah.
Okay.
I mean, they've got 2 attorneys and a staff paralegal.
And the
So
reason
I'm
why,
betting,
sorry.
I'm betting that they're not doing it because they want to help the kids. I'm betting that they're doing it because they want to, you know, not do what parents are requesting.
Well, and the reason why I asked that question is I don't want to scare parents off from
Hiring.
you know, seeking
Help.
either an advocate or an attorney
Right.
to understand
This is a
what's
very-
going on. I mean, this is a very emotional situation. You're trying to get your kid, your child, help that they need. So that was the point of me asking that question about, you know,
Sonia, would
advocates.
you say that this case is kind of unusual in that fact that she brought an advocate and then all,
Heck broke loose?
yeah, everything broke loose?
Well, I wish I could say that was the case, but I think it's increasingly becoming a more litigious situation, and particularly in Texas. You know, I've been around long enough that I remember having interesting meetings where, you know, the parent would contact me and I would, you know, reach out to the school attorney who would say, oh, call the special ed director and work it out, you know, and that is literally how many things worked in my early days in this practice. And I think part of it is that it's sort of this conundrum that schools have of, you know, believing that they get to call the shots, that the decision is theirs, you know, that they have all of the answers, and that does not really lead to collaboration. That really leads to adversarialness and confrontation. You know, if the response to Lisa had been, oh, sure, we'd love to have you and your advocate. We look forward to seeing her.
Yeah, let's work together.
You know, or can we call her ahead of time to fill her in, or, you know, things like that. I don't think you'd have had, you know, some of this other stuff developed. And, you know, interestingly, at the meeting that they had where it was decided he wasn't eligible, if you listen to the tape, and I think this is what happened with the court, is they listened to the tapes. If you listen to the tape of the February meeting, it's not obvious until probably 2/3 of the way through the meeting that the school staff is not even talking about doing an IEP. They're talking about what he doesn't need. And the parents are still trying to, like, talk about the IEP until at some point the advocate says, you're like saying he's not eligible or something to that effect, you know, and they're like, yeah, he's not eligible. We don't have to talk about this IEP because he's not eligible.
Wow.
And, you know, the advocate tries to save it by saying, but you already did an IEP. Why don't we just use the one that you already have? You know, you're going to at least give him the one you already created, right? You know, and they're like, no. So, you know, I think it got off track. Who knows why? But we do know that that Leander had a habit of always bringing attorneys if an advocate was coming. They would have attorneys, and they did in Lisa's case. They had attorneys go to meetings when I wasn't even present.
Oh. So you just had them there all the time on retainer.
I mean, these were their outside attorneys in addition to their in-house attorneys. You know, so a parent would go to an ARD meeting, and, you know, if you had ever requested a hearing or anything else, you know, you're going to have an attorney at that meeting.
Do you think that this, and we're about to run out of time, but do you think that this court case and you guys successfully winning so many times in so many, like 2 district courts and the 5th Circuit. Will this have an effect, a positive effect on Leander, or do you think they'll continue to do this sort of thing?
I really don't know what Leander will do. Couple things in relation to that is, I think that the district is going through some changes. The superintendent has recently resigned. We don't know who's going to be the new superintendent yet, or at least I don't know. I would hope that the new administration would take a look at this and say, what are we doing? We've spent probably a lot of money, doing this, and what did we get out of it? What did we as a school district get out of it? I think that they were of the belief that that this theory of theirs that, well, you can't have special ed if you're able to make any progress in regular ed, was their goal with this case. I think they wanted to take this case and take it all the way up to show that kids like this one should not be eligible, so they don't have to serve them. That was their philosophy based on the testimony from Uli Crane.
Let me go back to Lisa real quick. Lisa, you still there?
Yes, I am.
So Sonia I know we're having audio issues today and some technical issues, obviously, but Sonia just gave us the whole rundown of the court case, and I know you can't hear what Sonia's saying, but what my question to you, and I think viewers will want to know as well, how are you guys doing now? Is your child getting the services he needs? Is he heading in the right direction?
He is heading in the right direction. We obviously are no longer in Leander ISD. He attends a charter school where we have found a group of people that kind of get it and are at least willing to collaborate and listen to parents and try to do what is best for our son.
That's so wonderful. That's very heartwarming. I'm glad after all of that, that started, first, second grade on into middle school.
Well, at the end of the day, parents don't want to go in and fight with the district about all of this stuff.
Oh my goodness, no.
No.
Think about the hundreds and hundreds of hours that
Emotional
you spend,
energy even.
Just dealing with this. And, let's just get the kids the help that they need.
Right.
Let's make some progress, and we can all be friends and, move
and help
forward.
kids.
And you help kids, and they don't have the,
That's
they
a
don't
good.
have
That's a win-win.
it's better to help them now than try to help or fix a broken adult.
Right.
Let's don't do that.
So Lisa, tell your child that there are, go home, love him, hug him, and tell him that there's, I'm going to get emotional.
This hits kind of close to home for you.
I'm going to stop. But tell him that there's like 500 or let's just say 1 million kids and parents and grandparents in a huge stadium cheering for him.
Thank you very much.
And that's all I'm going to say.
Thank you very much to both of you for all you've done. Because this not only helped your son, but it does help the rest of the kids that are here in Texas, and that's kind of why we do what we do, because there are kids out there that don't have the parents that can stand up and demand the help that they need and make sure that not only their kids but all the other kids in their specific ISD gets the help and become the child or the student that they really can be. So
that was certainly our hope, was to, at the end of all of this, that we ended up in a situation where the outcome would help others too, not just us.
So thank you very much.
Who knows? Maybe he'll be Sonia's protege someday.
I'm going to remain hopeful on that. So we do want to say that we do have some events coming that we're really excited about. We have a dyslexia rally, or I should say Washington, D.C. is having a dyslexia rally on...
Say Dyslexia Rally on July 9th.
Yes, take
And
a look.
you're looking at two of the guest speakers.
Yeah.
We're going to be there.
We were asked to speak at the rally, which is really cool. Hopefully I won't cry this time.
So if you're planning on going to Washington, or you can, come join us at the Capitol.
Yes. Go to Eventbrite and reserve your free ticket and join us there. That should be fun.
Like we say at the end of every show, if you feel like your child is struggling, just like in this case, regardless of making good grades, but you know that there's something that just isn't right, trust your gut feeling. Go request in writing
Y'all.
an evaluation. We have templates on our website, www.empowerdyslexia.info, that you can fill out the template, send it in to the school counselor and or special ed coordinator, and get your child tested.
And that's private school too. If you're in private school and you need to have your child evaluated, you can call and
Your local ISD that you pay taxes in.
Yep.
And get the same testing.
Via
through.
Child Find, they will test your child. But you're still going to need that letter.
Right. So make sure that you
And
do
record all your meetings.
Yes, that is legal in the state of Texas. And I've had more than 2 people tell us that that's okay. It's
So-
good practice.
That's all the time we have today. I want to thank Sonia and Lisa for joining us. Thank you again for all that you've done for, on behalf of the kids here in Texas that need this help and the families. You've done amazing work. Thank you very much. Be sure to like us on
Thank
Facebook.
you both for having us.
Thank
You
you.
bet, Lisa, anytime. And you too, Sonia.
Thank you.
All right.
Make sure that you like us on Facebook and YouTube. Remember, we're trying to get to that 1,000 subscriber and follower.
Yes.
So-
And there it is. All right.
So make sure that here's all of our platforms that you can hear us on. Obviously, we're live on Facebook and YouTube every Thursday at 11 Central. You can hear us on all of our favorite apps: iTunes, Google Play, Alexa, TuneIn, Stitcher, AnyPod. Basically, anywhere you want to listen to Empower
Anywhere.
Dyslexia,
We're there.
we're there. So,
All right. Y'all have a great week, great weekend, and we'll catch you next week.
see you there.